Morning, Your Honor.
Good morning. Morning, Shara.
Your Honor, it appears that the defendant is not going to be in the hearing today.
Yes, you sent me an email.
Yes, so if you would allow me to read the statement and proceed.
Yes, of course.
Thank you. This hearing is in the matter of case number CFI 070-2018 before Justice Lord Angus Glennie. The hearing is being held by way of video conference at the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by Tamimi and Company. Lead counsel is Mr. Sharif Shifji QC. The defendant is not present. Thank you.
Thank you. Yes. So you're unopposed today, but I can tell you I've read a substantial amount of the pre-reading you asked me to do, although a 2-hour estimate is rather ambitious. Perhaps a more realistic one can be given next time. Given that the affidavit, the witness statement is 50 pages long, the first one, and if I was going to make any sense of it, it requires more than 2 hours altogether. Anyway, yeah, what do you want to say?
I'm grateful for that, my lord, and that point is well made. I apologise for that. We will be more realistic in the future. My lord, today before you there are 2 applications. There's my application for an unless order against the defendants in relation to their document production, and there is also the third defendant's application for immediate judgment. As appears to be the case, the defendants don't appear. And I'll deal with the immediate judgment application second, if I may.
Is that application formally before me?
It has been listed before you, so today is meant to be the substantive hearing for that application.
Right.
But our submission will be that in circumstances where it's not being moved before you, the appropriate order would simply be to dismiss it.
Yeah. Okay.
But if I may, I'll come to that in turn. And the meat of the application and today's hearing is the unless order application. And I'm very grateful that your lordship has taken the time to do some pre-reading, and I'll try to take.
I should say I can't pretend to have gone into all the details in the schedule to the old skeleton. I've seen the nature of them rather than identify the individual points.
I'm grateful for that indication, and in our submission, in fact, that is the most important point, that your lordship gets a sense of the nature of the complaints that we're making, and also the substance of them and why they are relevant to the central issues in this action. But if I may, your lordship, before turning to those, I may make a few remarks about the parties themselves. And the proceedings, just so that your lordship has the right context. My lord, this, as you know, is an action for the recovery of a debt against a substantial group of UAE companies and their wealthy owners. The defendants themselves, the corporate defendants, are members of the Delma group of companies. And the Delma Group and their individual members were very significant businesses in their own right. There were at least 3 auditors of the companies that we know of, including Ernst & Young and Deloitte. Oh, I see that Mr. Al-Hashimi, who is the judicial guardian of the third defendant, has appeared.
Yes. Good morning.
Good morning.
Are you here to present the case on behalf of the third defendant, or are you just here to observe?
Let me explain the situation. You know, I just handled the company ago, but the situation happening before I joined, long time ago. And now I didn't have any support document, any document. We are just on behalf of the company, in behalf of the court. So currently I didn't have any idea about the case. I didn't know what happened, and I didn't have the support document in the company said.
Right.
And I think Al-Anud is supposed to attend the meeting, and she can explain well.
Who is this? Who's going to attend the meeting?
Al-Anud Al-Amriqi. Mr. Anud Al-Marikhi, she's supposed to attend this meeting to explain the case or represent
This hearing,
Yes.
Your
today.
Honor, Mr. Lanud is one of the defendants who we have been communicating with, and
You've gone off, Shara. Hello? Shara?
I apologize, Your Honor. Can you hear me? I was having connection issues.
Yes, I can hear you. Can you start
Yes,
again?
Ms. Lanud is one of the defendants in this case who we have been communicating with, and she had emailed yesterday stating that she was not going to make it to the hearing today. So if she shows up, I think that's a change in plans. Please let me know how you would like me to proceed.
Yes. Well, you heard that. Apparently, Ms. Lanud, is it? Has said that she's not intending to appear today. Do you have any contrary information?
Mr. Al-Hashmi?
Mr. Lashmi?
Yes, I didn't have any information. It's supposed to, we have an advocate to represent us, and we want to, we need a bit of time to prepare our document and represent our advocate in this case.
Right. When were you appointed?
We have one in Abu Dhabi, and we will check how can we go for the process of appointment.
I just want to know when were you appointed in your position for the third defendant, Delma Engineering?
When I have my advocate, Mr. Hassan Riyami, and he will present me in all the case, but I don't have the Dubai financial situation, but we will see how can handle this. Just we need a little bit time for the processing our advocate.
Right. Hold on a moment, Mr. Shivji. Is Shivji, is it?
Yes, it is.
What do you say about this?
Firstly, in answer to your, sorry, Your Lordship.
I said this unexpected turn of events. What do you say about it?
I'll make a few points, if I may. The first is in answer to Your Lordship's question. Mr. Al-Hashimi was appointed in December 2018. So he has been the judicial guardian of this company for some more than 3 years. He also swore an affidavit in this matter on the 9th of November 2021 in relation to the third defendant's document production. And there was a lot of information given to Your Lordship, but one of the points made in the evidence is that affidavit is very unsatisfactory, not least because sections of it have been copy and pasted from other affidavits. And in one of the sections, Mr. Al-Hashmi refers to his sister, which is simply a cut and paste from the two siblings' affidavits, D7 and D8. And so our submission on that is that it was evident that Mr. Al-Hashmi had not read his affidavit very carefully, because if he had, he would have realised that there was an erroneous reference to his sister. So he has been involved in this litigation for some time, and as the judicial guardian, he is responsible for conducting this matter as a court-appointed officer. It is his application that is the immediate judgment application. Now, I've explained in my skeleton argument why that application is misconceived as a matter of fact and law. In our submission, the court should deal with that application today. And in the circumstances, insofar as Mr. Al-Hashmi is making an application for an adjournment of that application, that's unsubstantiated, and the court should dismiss it. And then, as regards the unless order application, as Your Lordship will note, this claim has been going on now for 3.5 years. Regrettably, the defendants have deployed a range of tactics in order to delay and obfuscate the continuation of these proceedings. And it is unexplained as to why none of the individual defendants have appeared today. Miss Alanoud is actually the sibling of the 7th and 8th defendants, so she is not currently a party to these proceedings, but it's her address that has been given for them as the address for service, and she is the person who appears to have active conduct of this litigation for them, and we have no explanation as to why she's not here. So for all those reasons, it's my submission that we should proceed today.
Yes. Mr. Al-Hashimi, is it?
Yes.
Do you are you prepared to argue your case for immediate judgment?
Just give me, Your Honor, can you give us a time to prepare our document? Since Ms. Alanoud,
you've had since this case has been fixed to come on now for some considerable time.
Yeah, but this is our situation. When I taken over the company, I didn't have any documents. I didn't have any for this.
You took over the company December 2018. Is that right?
Yes.
Have you been corresponding with the court since then?
Yes, because we are focused on the labor case court, and that's it. But for this case, I didn't know about it indeed, because previously I have one advocate, and I think there's some problem, and we didn't continue with them. So what I needed a little bit time for to prepare our document and our reply for this.
Your Lordship, I'm sorry to interject, but I think that point that Mr. Al-Hashmi just made requires correction. When he says he doesn't know about this application, he signed a witness statement in support of it, which is the main evidence, which was on the 17th of November 2021, which is in the bundle. And in relation to the communications after his legal representative ceased to act in this matter at the end of January, we have been emailing him regularly, and we have not had any response at all to any of those emails. So we also wrote to his office, and that letter is in the bundle, and we had no response to that at all. And I haven't heard from Mr. Al-Hashimi any suggestion that none of those emails arrived and that the letter didn't arrive. So he has had a long time where he knew that the application that he initiated was coming on, and regrettably, he appears to have been ignoring our communications.
Is that right, Mr. Al-Hashmi, that you haven't responded to communications?
Actually, Your Honor, let me explain you the situation of the company. We are facing the cash flow issue, and we need we get a little cash from the owner to cover the advocate cost. If we didn't have this money fund, how can our advocate represent us? So it's out of my hand for me to defend on this document without my own advocate, and the owner of the company dealing with one of the advocate, and they have some issue of that. So even me, how can I am responsible to present or to reply for this case without my advocate?
Why have you not communicated with the other side?
We already tried to communicate with the Mr. Al-Murihi for this issue.
Well, the hearing there's been discussions about this hearing since January.
Yes.
And the date was fixed, and you never said the problem with appearing because of lack of funds or lack of counsel. You've never asked for this hearing to be adjourned.
Your Honor, I didn't know the situation in the Dubai court like this, and most of the time the advocate who represent us, and this issue happened recently, the last 3 months.
Right. And have you got an advocate now who could represent you?
Mr. Hassan Riyami, now he can handle this. And we,
When
the advocate,
was he appointed? When was he appointed?
I think we returned it back 1 month ago. No, 1 month ago and we handled the case 1 week ago.
So he was instructed 1 week ago?
Yes, yes.
And has he not prepared for today's hearing?
Yes. And unfortunately, we have some issue, and he cannot represent.
So he doesn't represent you now?
No, he represent, but he needed some process to represent it later on. Just we needed time for this.
How has he been preparing for this case in the last week?
We dealing with them, and we submit all documents which I get it from the other party, and he preparing it.
Why isn't he appearing today?
This is the issue. I must back to Al Anud to explain me this situation.
No, I don't understand. Sorry. Why, if you have an advocate, why has he not appeared in this hearing today?
I sent him all the documents, and supposed to attend. That's why I attend. When I found he didn't attend, I must call him back after this hearing and discuss with him.
Well, is it possible for him to appear if I gave you half an hour for him to come to court and explain the position?
I would try to call him. And to explain.
Mr. Shivji, it seems to me that we're not going to make much progress unless I find out at least what the position is about the third defendant's advocate. Do you object to me giving some time for, say, 20 minutes, half an hour for communication to be made and see whether we can get the advocate to join this hearing?
Okay, wait a second.
Wait a second.
Okay.
Mr. Shivji.
My lord, I'm grateful, and I appreciate your lordship's been put in a difficult situation. So I'm content with that. Could I just make two observations, if I may? One is that the Al Rayami law firm that Mr. Al Hashimi refers to is a firm that has acted for the Al Maraki family for some considerable time in relation to the very extensive onshore litigation that they have going on. So this is not a new firm. This is a firm who has already been on retainer for the family for some considerable time. Secondly, I am troubled by Mr. Al Hashimi's repeated references to Al Anud Al Maraki and the suggestion that he is waiting for her to take the lead or make decisions. Mr. Al Hashimi is the judicial receiver. He is the office holder. It is, in our submission, not appropriate for him to delegate his decision making for the company to a family member. And that, in our submission, underlies the problem with the litigation insofar as D3 is concerned. And then my third point is Mr. Al Hashimi did not provide your lordship with any explanation as to why he had not responded to any of our communications. The best that he said is that he wasn't in funds, but as a matter of courtesy, it would have been appropriate to at least acknowledge receipt of our emails and to explain that position. And in any event, his only point seemed to be that he tried to speak to Mr. Al Maraki. That is the sixth defendant. And again, that really underlines the problem that Mr. Al Hashimi is a judicial officer, and it is not his job to delegate the operation of this case to the beneficial owners of the company that he is now the judicial receiver of. So,
Your Honor, let me explain the situation. He just blame me as a justice concern, and I cannot handle everything because this family, they have the all documents and they have the idea about the situation. How come for me, which I didn't have anything to make the judgment? Now the company running without staff, proper staff, and the team can help me for the supporting documents. That's why I must back to Al-Barekhi family to get us this support documents. And why they blame me and I take all responsible since I get when I get the hand over the company, I didn't have this supporting document. I didn't have a team. I must back to the Mrekhi family to get me this supporting document. How can I delegate my task to them? I need the supporting document or related some cases. I must back to them.
Yes, I see.
Yep.
Right. So you are not taking instructions from the Al-Maraki family. You are seeking documentation from them.
At all. I need to them to give me some supporting document related to different case, because this take case long time ago before I came, and when I become in charge, I didn't have the all supporting document. That's why I must back from time to time to Amrechi family.
Right. Very well. I think what I propose to do is to adjourn this case until. Would you be able within, say, 20 minutes to get your advocate to appear on this hearing?
I cannot promise you, Your Honor, within 1 hour, I cannot call my advocate to attend this meeting. And just we need a little bit time to prepare our documents. Just what I am asking for this.
I need to know from the advocate, though, how long, what he is asking for.
Okay.
You are the client, if I put it that way. Your advocate is the person who knows the law and will represent your interests.
Yes.
So
yes.
Can you get him to appear by, say,
1 hour?
what time is it in Dubai, in DIFC?
1:30. Currently 1:30.
1:23.
Yes.
So by 1:45, could you try and arrange that he appears at this hearing?
Okay, let me try to call them, and I will come back definitely at 1:45.
I'll resume at 1:45, and we will have to take it from there. Mr. Shivji, I'm open to any arguments that may be proper to be considered as to where we go from here.
Okay.
Once we resume and know what the position is. Very well. I'll adjourn now till 1:45 Dubai time.
Okay.
Thank you.
Thank you.
If you mute yourselves, then I can't hear what you're saying. Thank you.
Your Honor, now I get a call from my advocate. He will not continue the case. He stopped since January, last January.
Since January, what has happened?
He stopped the deal to continue. He sent me the letter.
In January? But
yes.
You only discovered now?
Yes. No. I know this now.
So I don't understand. It's my fault. But you say you spoke to him today, and he's told you he is not going to act for you anymore.
Yes.
But what was that about January? That he already decided in January?
Send me email for this.
But now it is March. Why have you not known this until now?
Now I'm preparing the advocate, new advocate for this.
Sorry, I'm confused. Do you presently have an advocate who can act for you?
Currently, didn't have advocate now.
Are you instructing a new advocate?
we try to find the advocate for this case.
So what about Mr. Carlo? He was instructed?
He was instructed. Now we stop.
When did he stop?
Last January.
Last January. But
Yes.
did he tell you in January that he had stopped?
Yes. He sent me official email.
So why have you not taken steps before now to find another advocate?
I try because, as I told you, I have the cash flow issue to find advocate to represent us in the case.
So you're not in a position at the moment to find another advocate?
Yes.
Very well. So if I adjourned, for example, for 2 weeks, it would not help you?
If I will try to do the best. If you give me the 2 weeks, we try to do the best for this.
No, but I'm not going to adjourn just on the hope that something will happen.
I will try to do the best, Your Honor. I'll try to do the best.
I'll hear what Mr. Shivji says about this. Mr. Shivji, as I understand the position, the advocate who was instructed on behalf of the third defendant has he ceased to act. He said he wasn't going to act sometime in January of this year, and the third defendant has taken steps in the meantime, or tried to take steps to find another advocate, but doesn't have the funds to do so. I think that's right. What do you say we should do now?
So our position, my lord, is that the appropriate order is to dismiss the application. Perhaps I could just address you for a moment on the explanation that Mr. Al-Hashmi's given you. As we understood it, the break that we took was so that Mr. Al-Hashmi could call Al-Rayami advocates, who were an onshore firm. And as I understood what Mr. Al-Hashmi told you earlier this morning, was that he had sent the papers to Al-Rayami a week ago, and he was phoning them to find out whether they could then appear at today's hearing. It appears that then what Mr. Al-Hashmi did was phone the former legal representatives, who were Carlo Fedrioghi, who, as we all know, came off the record on his own application at the end of January, and it was.
So that's the one.
Yes, they were the former advocates who came off the record. So, and Mr. Al-Hashmi fairly admitted that he knew of that at the time. So I'm at a bit of a loss as to what he told your lordship this morning about Al-Rayami and the fact that he'd sent them papers a week ago. But it sounds like Mr. Al-Hashmi is now backtracking from that. So I think it would be helpful to hear from Mr. Al-Hashmi on that front, if your lordship thinks it's helpful.
Yes, I think it would be. Mr. Al-Hashmi, I hadn't picked this up, but you mentioned before that you were going to speak to lawyers from Al-Rayami, and you sent them the papers a week ago. You're on mute. You're muted. You're muted.
Okay. Sorry, Your Honor. I sent him the documents, and we are under this discussion to handle this case. Needed time, maybe he did not register in the DIFC, so I need to find other advocate who register in DIFC to handle this case and represent me.
Why was this not done as soon as your previous lawyers ceased to act for you in January?
We have some situation happening, and that's why he cannot continue.
No, but once the lawyer ceased to continue, Mr. Carlo ceased to continue in January, why did you not take steps then with Al-Rayami or other advocates, other lawyers, to find someone?
Sorry for interrupting you, Your Honor.
You carry on.
Okay. Once I get the notification from Mr. Carlo, I try to find other advocates. It gives me a lot of time to find other one. That's why I back to Riyami to help me to find other advocate register in the DIFC.
Right. Okay, Mr. Shivji, that's the explanation we've got about Ariami.
Well, I'm grateful, my lord. So in these, just to sum up the position as we see it, Mr. Al-Hashmi is not in funds. He's made it very clear that he's not prepared to deal with any matters when he's not in funds. He's not even prepared to respond to emails from my solicitors or from the registry where he's not in funds. So absent his funding position changing, there is no prospect of him taking an active role in this litigation. He's also had more than 4 weeks to find an alternative firm in the DIFC. And from what he's just told your lordship, he has been making efforts to do so. As we all know, there's a public list of firms that are registered on the DIFC website. So the information is easily accessible as to who is registered to appear in these courts. And he's obviously made his inquiries and done the best he can. It's also clear from what Mr. Al-Hashmi said that there's no prospect of that position changing anytime in the near future, no prospect of a new firm coming on the record shortly or his funding position changing. So in those circumstances, we say that it would be inappropriate to adjourn the application and your lordship can deal with it today. We also say that it's an application that on the merits is doomed to fail. And I can address your lordship on that. And if Mr. Al-Hashimi wants to deal with it today, he can also deal with that today. But
leave aside the third defendant's immediate judgment application. What about your application?
Well, similarly on my application, I'd come back to the fact that this claim has been ongoing now for nearly 3.5 years. And regrettably, we have seen a range of tactics deployed by the defendants to stop the progress of these proceedings. And on my application, it is very important that it goes ahead today. The defendants have had plenty of notice. The application was issued at the end of December. Mr. Al-Hashimi doesn't suggest. I think Mr. Al-Hashimi might have just taken a phone call, Your Honour. Sorry, my lord. Do you want me to pause to wait for him?
If you pause for a moment, yeah.
Okay. 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 Your Honor. Your
Yes,
Honor.
yes.
I cannot say anything until get the instructed and fully instructed from my advocate. So
You broke up. Can you say it again, please?
I cannot reply what Mr. Shavi said. I want to speak with my lawyer to represent me for this case.
Well, immediately.
Madam?
Do you mean you want to speak to your lawyer now so he can represent you in 5-10 minutes?
No. I need a time for my lawyer to make the represent me. So I need the time to communicate with my lawyer, and he will explain all the legal issue, because I didn't have any experience with this case and the legal case.
When would he be ready to explain the issues?
Just give me a time for this.
No, are you talking about? Hello?
Yes, I hear you.
Your picture has gone away.
It's some connection. Yes.
Are you talking about talking to a lawyer for half an hour or so? Or are you talking about more than a day?
I need a little bit of time. I cannot solve this issue within half an hour or 1 day. I need time to.
No, I'm not talking about solving the issue. I'm talking about your lawyer explaining to us the position as to his ability to represent you.
Yeah.
And
the decision like that cannot come in within 1 hour. I need to come back to my advocate to discuss with them.
Right. Give me a moment. Mr. Shivji, I understand your client's concerns to make progress, given the history of the matter. And we needn't go into the history for the moment. I've read enough to know the concerns, at least, that your clients may have. But trying to think practically, is there any, if I were to proceed at this stage with the Mr. Al-Hashmi having appeared for the third defendant unexpectedly, because he told the registry he wasn't going to appear, or there was going to be no appearance. If he turns out unexpectedly and says he needs a lawyer, whatever the history may be, and perhaps the delays and all that we can go into, would you actually be gaining anything if I proceeded in his absence and ran the risk, therefore, of any order I made being set aside because it was ex parte, effectively, when the defendant wanted to have an opportunity to be heard?
Well, I understand.
Or you're saying there's a risk, it's up to you whether to take the risk or not?
So in our submission, it's a risk that we would be willing to take. Firstly, because technically this application wouldn't be ex parte. It is on notice. It's just on notice where the defendants have chosen not to appear. And therefore the defendants would face the burden of persuading the court after the event to set aside the order where they had chosen not to appear on a hearing that they had full notice of. Secondly, and I go back to the point I made earlier, Mr. Al-Hashmi has been made very clear that where he doesn't have funding, independent funding, he's not prepared to participate at all. And we have a real serious concern that this will simply drag on, and that it is open to Mr. Al-Hashmi to participate or not participate as it suits him, on the basis that he's not in funds, and if he's not in funds, he doesn't have to do anything. So the concern is we've obviously incurred quite substantial costs preparing for today. We've incurred very substantial costs pursuing this action, and the defendants have, we say, intentionally put us to a lot of trouble in this litigation, made us jump through many hoops, which we have done. But we are very keen to make progress. Now, I'm obviously in your lordship's hands, and I know your lordship's trying to do justice between the parties, and we obviously support that. But we do feel, putting it colloquially, that the defendants are running rings around us, and we do need to make some progress. Otherwise, this case will run into its fourth year without even having directions to trial.
It occurs to me that what I understand is submissions. It occurs to me that I could possibly achieve justice in this way, and it would depend upon everyone's availability. But to give Mr. Al-Hashmi and his lawyer until tomorrow to explain to the court, to confirm to the court whether he intends to take part and to be represented, and the lawyers to explain or to confirm that they are instructed and are able to prepare for the case. That includes finding a registered DIFC lawyer to act for them. If that confirmation was given, it was not given, we could have then the hearing effectively tomorrow as opposed to today. And if it was given, then it could be adjourned for a week or possibly 2 weeks until I'm just looking at a diary while I speak, either the 9th or the 16th, which is roughly 2 weeks from now, 1 week or 2 weeks from now, which would not involve, it would involve obviously more expense on your part having to attend a separate hearing, but it would remove some of the risk of injustice or potential injustice if I was satisfied that Mr. Al-Hashmi and the third defendant and his lawyers had been given every reasonable opportunity, despite their previous failures, to attend. Now, I'll ask you first what you may want to talk to your solicitors first, but if you want to have an immediate response, by all means.
I can give your lordship an immediate response. unfortunately, I'm in the English Commercial Court in a 2-day hearing starting tomorrow, so that causes me personal difficulties over the next couple of days. But could I put forward a counter proposal for your lordship's consideration? Perhaps one course is much of what I have to say today is directed at the other defendants, and it seems to us we could go ahead and use the time today productively on that front. Your lordship will hear as part of those submissions about the third defendants, but they're all wrapped up together. The complaints about their document production apply equally to all of them, the major complaints. But perhaps if your lordship is with me today, as regards the third defendant, your lordship the court perhaps could hold off sealing the order as against the third defendant until Mr. Hashmi has provided that confirmation. Because in our submission, it seems highly likely that Mr. Al-Hashmi will be unable to find a DIFC firm in the next 24 hours who are funded and able to take this case on. And if that is the case, then today could have been used productively and we'll get the order that we say we're entitled to. And if conversely, he does find a firm who are able to take it on and are funded to do so, then they will have to make submissions at that point as the appropriate course. And it may be that your lordship waits to hear what they have to say before sealing the order as against them.
I think Mr. Hashmi is on the phone.
Yes, Your Honor. I want to speak with. I need the time to speak with Mr. Riyami to prepare the advocate who registered in the DIFC.
What about the suggestion that the case go ahead against the other defendants?
I cannot say anything until, Your Honor, I cannot say any legal, make any legal judgment or advice until back to my advocates.
Right.
Your Honor, you must understand the situation. I cannot take any responsibility for this case without my advocates, you know.
Mr. Shivji, sorry to get back from the fours between you. If the third defendant presently has no assets, would there be a attraction to your clients of simply proceeding against the first and fourth to eighth defendants, and leaving altogether the application against the third defendant, leaving that out of account? It occurs to me from what Mr. Al-Hashimi has said that the third defendants probably don't have any documents at all, by the sound of it, or that he doesn't have any documents, and therefore an unless order in terms of producing documents would be pretty ineffective anyway.
So perhaps I could break that down into two parts, my lord. The first is that we recognise that Mr. Al-Hashmi, as a court-appointed office holder, is in a different position to the other defendants. I must say that it's a matter of some regret that much of what's been said by Mr. Al-Hashmi today suggests that he regards himself as in the same camp as the other defendants. And it's striking that he's speaking to Al-Rayami, who are the Al-Maraki, so the 6th to 8th defendants' own family lawyers. So that it does fill us with concern that he doesn't still recognise his independence. However, we recognise that he's in a different boat. And then moving to my second point, your lordship's question about the unless order, Mr. Al-Hashmi has given evidence pursuant to the court's order of last year about the documents in his possession, and we don't think that that is a full and frank explanation of the position. And your lordship has heard today a number of different accounts from Mr. Al-Hashmi on the events in question. They haven't been wholly consistent, and that rather underlies our concern that Mr. Al-Hashmi has not been as forthcoming with the court, as he ought to be as a court-appointed office holder. So I'm content in principle to put the third defendant to one side if that's the course your lordship wants to take. But it seems to us it's highly likely that we will want to proceed against him. Now, if at the end of the day, Mr. Al-Hashmi has a change in approach, starts communicating with us, is frank and open about what he has access to and his own funding or asset difficulties, we will look at that sensibly. I mean, we're not trying to get anything other than what we're entitled to under the rules. And we're very open to those discussions, but that would require a significant change in approach, because at the moment we have been stonewalled by him and by the other defendants, and that's why now nearly 4 months after he issued his own immediate judgment application, we're having an argument about whether or not he should be forced to either pursue it or drop it.
How would it work if you proceeded with your application against the other defendants, but not the third defendant? How would it work if Mr. Al-Hashmi, in a couple of weeks' time, said, "Yes, I now have an advocate"? I suppose the answer is it wouldn't affect it, because you wouldn't have an order against the third defendant, and you could decide for yourselves later on whether to pursue the same relief against the third defendant.
That's correct.
Is that right?
Yes, that's correct, Your Lordship.
Mr. Al-Hashmi, there are two matters today. First, well, one of them is your own application for immediate judgment.
Okay.
You're not here to pursue that application. Is that right? You're not in a position to pursue that application.
I cannot say anything, Your Honor, until back to my advocate, I cannot make any judgment or statement without backing my advocate, Your Honor.
Then it follows that since you haven't had a chance, or you haven't consulted your advocate, you're not in a position to pursue that application at the moment. It must. Therefore, since that application was listed for today, and you're not pursuing it, then that application must be dismissed. Of course, it's open to any party to make a new application, but that's a matter for you to consider. But the proper order as regards that would be to dismiss the application. The second matter is the claimant's application for an less order about the documents and an explanation about the documents. And in those circumstances, what is suggested is that the claimants will continue with today's application against the first, fourth, fifth, sixth, seventh, and eighth defendants, but not against you, not against Delma Engineering. They're not dropping the application, but they're not insisting on it they wouldn't be insisting on it for today. And therefore, the fact that you are not represented need not cause any prejudice to you. Do you understand?
What's it? Okay, Your Honor.
Did you understand what I was saying?
Yeah, yes.
So on that basis, if I were to make an order allowing the hearing of the claimant's application to proceed against the first, fourth, fifth, sixth, seventh, and eighth defendants, then that would not prejudice you.
Okay, Your Honor.
And you need take no further part in this hearing.
Yes.
Well, but then what I do urge, though, is that you still take steps to get legal representation, because because the claimants will, I have no doubt, want to proceed against Delma Engineering.
Yes.
The court will not be sympathetic if you have taken no further steps to obtain legal representation.
Okay.
So, Mr. Shivji, then what I propose is this: it's not satisfactory, but it's, I think, the best that can be done in the circumstances is that your application against, insofar as it can, sorry, I would dismiss the third defendant's application for immediate judgment as on the grounds not being insisted upon. I will adjourn your application as against the third defendant, Delma Engineering Projects Company, with liberty on your part to restore it as and when considered appropriate, and allow your application against the other defendants to proceed today unopposed. Does that make sense?
I'm grateful, my lord. And can I just confirm that we would, obviously on the immediate judgment application, we would get our costs of the application?
I can see no reason why the claimant should not get its costs of the application, which is dismissed, the immediate judgment application.
I'm grateful, and we would ask for them on the indemnity basis.
Just make sure that Mr. Al-Hashmi understands what I'm saying about that.
Yes, yes.
And you're asking for them on an indemnity basis?
Yes, and on the basis that the application has been unreasonably pursued. It would be unfair in my submission for my client to have to bear any of the costs of the application in these circumstances. So, I mean, I could develop those submissions if you're.
I understand. Mr. Al-Hashmi, the application is that you should pay the costs of that application, of your application for immediate judgment, on what's called an indemnity basis. That is to say, it's basically that they get almost the whole of their expenditure, as opposed to it being taxed by the court official on a reduced basis. And the reason for that would be that the fact the application has been made and not insisted upon and been outstanding for a long time with no prospect of it being pursued. And having seen and read the papers, I consider that would be an appropriate order in this case. Do you want to say anything?
I must speak with the lawyer about this, Your Honor. I must speak with him about this part.
I think we can't go backwards and forwards to lawyers. You've either got a lawyer appearing for you, or you haven't. You haven't at the moment. And I think, in fairness, it simply follows as a consequence of dismissing the application that you pay the costs. And in my discretion, I think they should be paid on an indemnity basis. And that's the order I'll make. Thank you. Now, you are not involved then in the rest of this hearing because it involves the other defendants and not the third defendant. So you are free to leave the hearing if you want to do so. But can I just emphasize once again the importance of getting legal representation, because there will be further applications in this case, and the court will not necessarily be sympathetic if you come along and say you need time to get a lawyer. Do you understand?
Okay.
Thank you very much.
Before, sorry, my lord, before Mr. Al-Hashmi goes on the indemnity, sorry, on the immediate judgment application, we have filed a cost schedule, and I was going to ask your lordship to summary assess the costs of that. That seems this is a one-day hearing. It's the sort of thing that the court would normally try and achieve in a day. So I know it's a slightly tiresome process.
That was the schedule for the immediate judgment application.
It was a schedule for both, but I can give, if you just give me one moment, my lord, I can give your we've estimated a percentage of proportion. Sorry.
The difficulty is that Mr. Al-Hashimi is not able to. It wasn't served on him, I don't think. He hasn't had an opportunity of commenting on it. And I think the best thing is to be assessed by the registrar, if not agreed.
I'm
afraid.
I understand it. It was actually served on him, my lord, in accordance with the rules. But can I perhaps I could suggest?
Right.
Sorry,
was that last night?
No, it was. It should have been yesterday. The rules require it a day in advance, and we're just checking the time. But my solicitors did prepare it in time, so I hope it was sent in time.
I received it this morning.
Yes, I know. I think the reason you received this morning was due to some issue with uploading it to case lines, not with it not being prepared on time. But let me just check that. I'll just check. My junior's just taking instructions on that, and I can tell you about the point that it was prepared and sent across. Awesome. Oh right, my lord, I'm so sorry. It sounds like it was only served today, and I'm so sorry for what I said a moment ago, which was incorrect. So I apologise, to your lordship.
In those circumstances, I don't think I can expect Mr. Al-Hashimi to deal with it. And the better course is to award costs on that basis, but to leave them to be assessed by the registrar in the ordinary way.
I'm grateful. Could I, when we draw up the order, perhaps I could just include a provision that assessment can happen now rather than having to wait to the end of the proceedings, because that may.
The assessment can happen, whatever the official terminology is, it can happen straight away.
I'm grateful. We'll put that into a draft order, and we'll send that to Mr. Al-Hashimi to have a look at and to your lordship. But I'm grateful, and I apologise, my lord, for what I said a moment ago about that schedule. It was my understanding it had been prepared on time. I'm not quite sure where it went awry.
Mr. Al-Hashimi, as far as you're concerned, then that is the end of your necessary involvement in these proceedings. And as I say, we've made this order, but the rest of the application does not include an application against you or your client.
Okay. So can I leave? Thank you.
Yeah,
thank you.
Yes, thank you. Thank you for coming.
Thank you.
Shala, could you possibly record the moment at which Mr. Al-Hashimi left the hearing?
Yes, Your Honor.
Thank you.
Time right now is 2:22 p.m. Dubai time.
Yeah. If you just make a note of it for the record, and perhaps it may go into the order in due course.
Yes, Your Honor.
Thank you. Right, Mr. Shivji, I'm afraid any order made in this case sounds as though it's likely to be unsatisfactory for someone. But there we are. Whether it matters is a matter I can't judge on. Now, how do you want to do it? I've read your skeleton argument. I've read the complaints made against the, I'm going to call it discovery because I'm old-fashioned, against the discovery given by the other side and the explanations on affidavit as to what's available and what's not and why it hasn't been produced and so on. So I'm not sure that you need to take me through line by line. What occurred to me was this, that I was wondering whether an order is the right approach, and I'll tell you why I say that. If you look at your draft order, the unless part of it is in paragraph 1. Unless they do these various things, the offence be struck out. Paragraph 2 it doesn't arise for the moment. Paragraph 3, the explanations to be given in A and B are matters which the question of whether there has been compliance will be a matter of judgment. It's very difficult to operate in a less order where it's triggered by something which one party will say is unsatisfactory compliance and therefore non-compliant. Other side will say they've done their best. You'll have to come back to the court anyway to rule whether there has been compliance. In those circumstances, I wondered whether a better approach was to exclude paragraph 1, but in a new paragraph towards the end, fix a hearing, say 21 days from the date of the order, to allow the 7 days for compliance and the further 7 days for affidavits and witness statements. Fix a hearing at which the court will consider, in light of any alleged failure by the defendants to comply fully with the order, whether to strike out the defence or any part thereof, and or enter judgment for the claimants, something like that. Because you're not, unless it's a clear thing like produce a particular document, because an unless order doesn't really work. That's my experience anyway. But then you tell me if modern practice says otherwise.
So your lordship's absolutely right that the mechanics of an unless order need to work, and we recognise that there are a variety of different outcomes as to how the defendants will react to this order. At one end of the spectrum, we simply may hear nothing from them. Recent experience suggests then it is straightforward. But your lordship is right that if there is some degree of compliance, then there may well be an argument about compliance, and that would probably have to be adjudicated on by the court. Perhaps I can take instructions on your lordship's proposal, if I may, because I think that probably does make quite a big difference to the time I need to spend at this hearing. Is that possible? Could I have a few minutes, my lord, to do that?
Of course. Can I just say the advantage of the thing I'm proposing is you get a date fixed now,
yep,
at which the adjudication of whether to strike out effectively is made quicker than you would do perhaps if you had an unless order and then had to list something for a hearing in due course.
Yes.
Okay, how long do you want?
Could we have five minutes? And my lord, that attraction is well understood, which is why I think I need to speak to my solicitors about it just to understand their viewpoint. So perhaps we could have 5 minutes if that was possible.
Let's say it's nearly 10:30 UK time. What's that? 14:30. Make it 14:40.
That's sorry. Sorry, my solicitors have asked for 15 minutes, and perhaps we could say 14:45.
Yeah, 14:45 Dubai time.
I'm
Very
grateful.
Well. Remember to mute yourself.
Thank you. Yes, I will do. Thank you.
Yes. Ready to resume?
I am, my lord. I'm so grateful for the time. It was very helpful. So, my lord,
I apologize, Your Honor, if I may just intervene for a little bit. Ms. Alanoud, she is one of the defendants who told me yesterday she was not going to make it to the hearing today, is on the phone with me on the other line and emailing asking to join the hearing. So, Your Honor, if you could give me orders or directions, please.
Well, I can't stop her joining the hearing. Who does she appear for?
I believe she appears for one of the defendants. I'm not sure, but she's the person. Her older Mr. Carlo, the older representative, had given me her email information and told me to contact her. She's been in touch with the court. She's been aware of this hearing. She kept asking for extensions, but the registrar did not allow for an extension because she was trying to file it yesterday.
Right. And what's her name?
Alanoud. Let me just confirm her last name. Apologies.
Can you spell that for me?
It's Alanoud, ALANOOD. Alanoud. Her last name is ALMERAIKHY. Al-Muraikhi.
See, it's the same family as the 6th, 7th, and 8th?
Yes, I believe she's a family member.
She's the daughter of the 6th defendant, and she is the sibling of the 7th and 8th defendant.
Yes, I see. And she wishes to appear. Well, I can't stop her appearing if that, unless you have any point to make on that, Mr. Shivji.
I think, my lord, our view is the best course is to hear what she has to say, and then if I have observations to make, I'll make them.
Yes, thank you. Yes, well, Sharda, do you want to? Is she ready to join us now, or does she want? Do you need
like,
to do it?
Like 30 seconds. I'm just sending her the link again.
Okay, well, if you do that and tell us when she's ready to join.
Yes, Your Honor.
Thank you very much.
Thank you. Apologies, Your Honor. She's having some issues with the Teams, I think, but she's about to join.
Hello? Hello?
Hello,
Hello?
is that Miss Alaraki?
Hello?
Yes, hi, Miss Alinud. Can you hear us? You're in court right now.
Yes. Hello?
Sharda, if you can try and make contact.
Yes. Hi, Miss
I'm
Alanud.
trying.
Can you hear us?
I can hear you. I can hear you, and I'm trying. I'm just waiting for someone to get me in the meeting.
You are in the meeting, ma'am.
Okay. Good afternoon, Your Honor.
Do you want to turn your camera on?
This is a phone call, Your Honor. There's no camera because
Okay.
it's a phone call.
Right. You are, do I call you Miss Alanud or Miss Adaraki?
Miss Alanud.
Miss Alanud. And you want to join this hearing on behalf of whom?
I'm on behalf of the defendant, Your Honor. My father, Mr. Ahmed Al-Mureki.
Yeah.
And
Just
my two sisters.
Yeah. So that's the 6th, 7th, and 8th defendants.
Correct, Your Honor.
And not on behalf of the 1st, 4th, or 5th.
The 4th and 5th.
The 4th is Delma Emirates Diesel, and the 5th is Delma Emirates General Transport. Are you seeking to to act on their behalf too?
Yes, because it's under my sister's name.
Well, they are companies, I think.
Yes.
Do you have specific instructions to act on their behalf?
Yes, Your Honor. I would like just to say that we had some financial difficulties and we were not able to instruct a lawyer or a barrister. But our local lawyers, who's Mr. Adriami, had filed a criminal complaint in Dubai, and we understand that the public prosecution is in the process of investigating, and that they will take the originals of the facility agreement and personal guarantees that has been provided from IDBI to the criminal lab. And from the beginning, they said that we had some doubts because the IDBI had changed their witness statements 3 times, which first stated that they...
Ms. Alanud, you're coming
Your
into
Honor.
you're making submissions about something which there's no motion on behalf of you or your family.
I cannot hear you, Your Honor. I cannot hear you, Your Honor.
There is
Hello?
no motion. Hello, you have not made any application to do anything other than appear at this hearing, which is for the claimant's application for an unless order about documents. What are you asking for? Hello?
Not asking anything, Your Honor. I'm just stating that the defendant had opened a criminal case on IDBI where they say on the facility agreement of the documents that they stated it has been signed by my sisters and my father, where my father was out of the country, and the witness statements of the bank's employee has been changed 3 times. I just wanted to add this, Your Honor.
Right. Well, unless there is any application, for you to do, for me to do anything, I have to proceed with this hearing. Is there any objection to that?
Your Honor. I will apply. I tried to apply yesterday, but it was not the application. I wasn't granted the application. So I will apply, Your Honor.
For what?
On the same hand, we are trying to retain lawyers.
What are you applying for?
Excuse me, Your Honor?
What is, you say you are applying or you want to apply. What do you want to apply for? What order do you want made?
Your Honor, for a stay of the case.
Why?
Because, Your Honor, as I mentioned, that we have already, because of the criminal case that we have opened in Dubai against the IDBI employees and the documents that they have provided and which they state it has been signed by my father, where he was out of the country, the date and the month and the year they say they met with my father and get it signed along with my sister.
Right. You presently have no application filed in court.
I have not, excuse me, Your Honor.
You have no application presently filed in the DIFC court.
We will, Your Honor.
At the moment, you do not have.
We will apply, Your Honor, if they will grant us approval for the application.
Right, Mr. Shivji, I can probably anticipate what you're going to say, but do you want to say, make such submissions as you want?
I'm grateful, my lord. But perhaps if your lordship will forgive me, I might start by asking a question that Ms. Alanud might want to respond to, which is that the criminal complaint she's just mentioned hasn't been raised before, and it would be helpful to understand from her when that criminal complaint was made.
Yes, can you help on that, Ms. Alanud?
Can you repeat again, please?
Mr. Shivji, do you want to repeat it?
Because it was disconnecting.
The criminal complaint. Can you tell us when that was initiated? Started.
I'm sorry. I'm not authorized for the time being to discuss it because I don't have, first of all, a lawyer appointed with me now, and we will disclose further information.
Ms. Alanud,
we will yes, Your Honor.
You must be able to say when the criminal case was started. When was it started?
We have filed it, and I cannot. I'm sorry, Your Honor. I cannot answer now. The lawyers should answer on behalf of me because they have placed this criminal case.
Well, Ms. Alanud,
yes,
at the moment you are asking me to stay this case.
Yes, Your Honor.
Yes. You're asking me to stay the case. You're asking me to stay the case based upon the fact that there is a criminal prosecution in Dubai against Idbi Bank.
Honor. Correct.
But you will not tell me anything about that criminal case.
I will. If you would allow me, Your Honor, I can email the DIFC, the lawyers who I will appoint, or the defendants appoint will email the DIFC with the all information about the criminal case, the case number, and when it has been applied.
Are you saying you don't know?
Your Honor, I just need more time.
Are you saying you don't know the answer, or you won't tell me because your lawyers have told you not to?
No, Your Honor, I do not know the answer for the time being because they have been instructed from my family and from my father and my sisters. And I honestly speaking, Your Honor, I do not know the exact date. As far as I know, that there is a criminal case has been opened, and they do have the reference number of the case. And Your Honor, if you would just give me one more week, and the lawyers that been appointed from my family would email the DIHC court with the information.
Well, Ms. Alanoud,
If you can accept that,
if you are applying for a stay of this case, you have to put before the court proper material on which this court can act. At the moment, there is no material that the court can properly consider to support your application. So I'll hear what Mr. Shivji has to say, but I'll hear what Mr. Shivji has to say.
I'm grateful,
Your Honor, I really do respect that, but please, Your Honor, if you can just give me 1 more week extension of time at least, Your Honor, we will email the DIFT court with the case number and the prosecution, as well as the criminal case that has been filed with the exact dates.
Let me hear what Mr. Shivji has to say.
Sure.
Mr.
Sure,
Shivji.
So my lord, Miss Alanoud said she couldn't tell you the precise date, but she obviously knows roughly when it was filed. On my team here, this is the first we've heard of a criminal complaint. In our submission, it's obvious what the defendants are doing. They have gone to ground in these proceedings and then have gone off to another court, and it sounds like filed a criminal complaint against the bank and the bank's employees. And that is I'll say it clearly, an improper thing to do. It's designed to put the bank under improper pressure in circumstances where this court is already seized with all these issues, and that this court is trying to deal with those issues fairly and justly. And I'm afraid to say that is a tactic that we have seen the defendants deploy against other members of their own staff, and it is highly regrettable. But turning to the immediate application that Ms. Alanoud makes, she says a stay of the proceedings or the application. Your Lordship will know that a case management stay is only granted in rare and compelling circumstances under the right called authority, which is upheld in this court. The defendants are a long way away from that. Indeed, my submission is what Ms. Alanoud has said today emphasises the need for this court to act with expedition and decisively against these defendants, because they are regrettably bringing this court into disrepute. So I would ask your Lordship to reject any application Ms. Alanoud makes. And in any event, there is a proper question about Ms. Alanoud's authority. The companies ought to be appearing by legal representative. There's no explanation as to why the individual defendants are not here. But the individual defendants are obviously active because they are busy filing criminal complaints elsewhere to cause the bank intended difficulties, rather than facing justice in the court seized with the issue. Those are my submissions.
Ms. Alanoud, it seems to me you have made an application for a stay of these proceedings on the basis of your assertion that the criminal proceedings have been commenced in Dubai. I know nothing about those proceedings. You won't even give me a date or any other details about the proceedings. On that basis, I cannot possibly accede to your application to stay the proceedings today. I will refuse that application, and I will, of course, it's open to you to make another application whenever you think it appropriate, but any such application would have to be supported by full information about the criminal proceedings and why it is necessary to stay these proceedings meanwhile. But at the moment, all I'll do is refuse your application for a stay. Now, are you proceed?
Your Honor, Your Honor, I'm just a normal person. I'm not. I'm just a sister trying to defend father and sisters. I'm not a lawyer. I cannot understand even what, with all my due respect to the other party, I did not understand what he's trying to imply. But what I want to say is that I need time just to appoint a lawyer and email or make an application with all the information about the criminal case. That is what I'm asking. We're trying to defend. I'm trying just to defend my family, because what we have seen is that the bank employees had changed their statement 3 times, and they have not met my family. They have changed the date. They have changed, Your Honor, the place. 3 times the statement of witness has been changed. I'm just requesting you, Your Honor, just accept for me to file the application, please, Your Honor.
You can file an application. You can file an application whenever you have the information on which to base the application. At the moment, as of today, there is no application in writing, and you've made an oral application. By speaking, you've made an application for me to stay without giving me any relevant supporting material. On that basis, I've refused your application. We are now proceeding with the claimant's claim for an unless order in respect of the documents as set out in their application and supported by their skeleton argument. Now, are you proposing to take part in this part of the case, or what? Ms. Alanud, are you proposing to take part in this part of the?
I
Hello?
cannot, Your Honor. Yes. Hello.
I didn't hear what you said. Are you proposing to take part in the discussion about the claimant's application for an unless order?
I cannot, Your Honor.
Very well. So, if you do not want to take part, then you're free to leave the hearing.
Thank
if you
you,
wish
Your
to
Honor.
do. Thank you.
Thank you, Your Honor.
Sharla, can you note the time of Ms. Alanud leaving the hearing, please?
Yes, Your Honor. It's 3:10 p.m. Dubai time.
Also, when she joined the hearing, which was about 10:46 or thereabouts.
Yes, Your Honor. Yes, thank you.
Thank you. Right, Mr. Chifty, you were taking instructions from your solicitor.
I was. My Lord, before I turn to that, perhaps I could just make one observation on what we've just heard. This criminal complaint is highly unsatisfactory. The issues, if that's the right word for them, that Ms. Alanud described are within these proceedings. And if there are points that the defendants intend to take,
Mr. Chifty, I'm not going to hear argument about the stay application based on the alleged criminal proceedings, because it hasn't been properly supported. If a stay application is made in due course, that will be the time, I think, for proper argument about the subject matter of the criminal proceedings, if any. And
I understand, my Lord. I was making the point for a different point. In my submission, this rather underlies the need for the court to act swiftly to try and move this case forward, because we can now see what the defendants have been up to in the last month while we've had radio silence from them. Yeah. And so when I come to address your lordship on the order and the timescales for compliance, I'm going to ask your lordship to shorten them, because we now know that the defendants are not simply taking time to try and find legal representation, but instead are taking steps to try and undermine these proceedings by going elsewhere. Now, my Lord, on the question of the unless order, I've taken instructions, and we've also just looked at the rules.
which rule?
The rules that we made our application under 4.3.
Hold on. Yes.
We have also had regard to rule 4.20. And if your lordship will just have a look at that as well, please.
Yeah.
So what we had envisaged in our draft order was that the court would essentially invoke this procedure, make an unless order, and then if there was a failure to comply, we would then apply under 420 for judgment. Now we take your lordship's entirely fair.
Hold on a second.
Sorry,
You get a default order, an unless order under 4.3.
Yes.
And (420) is ancillary to 4.3, is it?
Well, I that's a fair point, but I think it is. So 4.21 says that if where the court makes an order which includes a term that the statement of case shall be struck out if the party does not comply with the order, and the party against whom the order was made does not comply with it. And then 421 provides that you can apply for judgment on paper.
Yes.
So that was the, sorry.
Yeah. Okay. Carry on.
So that was the procedure that we had in mind, but we recognise and have sympathy with your lordship's view that if there is partial compliance, there may be an argument over whether or not the unless order has been complied with, and the fastest route to resolving the issue is to return for another hearing, and we would be very happy to do that. And we would ask if your lordship has time in your lordship's diary, if that could come back before your lordship, just because your lordship is now up to speed on this matter and will understand from this hearing the direction of travel.
Well, just thinking aloud while you're talking about time, what sort of period are you talking about?
Well, we're in your hands. I mean, I think what we had in mind was providing for compliance with this order within 7 days, yeah, and then coming back to your lordship thereafter. I have a hearing next week in the first part of the week, but I could do a hearing later in the week. And I obviously, if I've got time in my diary, I'll make it available for your really to fit around your lordship's diary, which I suspect is more complicated than mine.
Your proposed order. Sorry, I'm just going to move my calendar onto the other screen. Your proposed order has two different timescales.
Yes.
Paragraph 2 is for 7 days. Paragraph 3 is for 14 days, and the rest, yes, all the rest, 14 days.
And my submission would be, my lord, in light of what we've just heard from Ms. Alanud about what's going on in the background, I would propose shortening all of these to 7 days. And
what does your motion say about your application say about this?
Let me just have a look, my lord.
Where do I find it?
It's.
I put it somewhere, but I can't think where.
It's bundle I, at tab 97, page 1408. That's the application and the draft order.
What does the order say in terms of timing?
It says 7 and 14.
The problem with curtailing it is that one always has to proceed on a basis, however unrealistic it is, that the party who hasn't appeared in light of what the application is. In other words, that they are content with 14 days, or not propose to argue about 14 days, but would argue if it was 7 days. I can understand your desire for speed, but it seems to me that I have to recognise that the application was only on a certain basis, and to give more than the application simply because the other party hasn't appeared is counterintuitive, and I'd have thought contrary to principle.
Well, I won't force that point, my lord. I understand that, and
what I had in mind would be if the order is drawn up, say today, the 7 days expires on the 8th, the 14 days on the 15th, and then you could have 7 days after that, because you would want to marshal the material or lack of it, and work out what the consequences are. Maybe on the 22nd.
Yes,
Now,
and is that a date that your lordship could accommodate us?
I could do the 22nd. I could do the 23rd, but and I could probably do the 18th, but that seems rather tight if compliance is by the 15th.
So the 22nd would suit me, my lord. And I hear what you say about in terms of the timings. Perhaps I could just develop the point about the extent to which the sanction needs to be spelled out in this order.
Yes.
Our view, we recognise and agree with your lordship that the question of compliance must be deferred to the hearing on the 22nd, and we won't get any consequences of the sanction until after that point. But out of an abundance of caution, we think the order ought to spell out now the sanction so that it's clear that we're within the 4.3 jurisdiction and indeed the 420 jurisdiction if we need to be there. And so I had a formulation of words which I hope will meet your lordship's concern, but also give me the flexibility to or argue that I'm within those rules if I need to.
This is really a form of wording which would modify or replace paragraph 1.
Yes, my lord.
Tell me what it is.
It may logically come later in the order, but I'll give you the wording, and your lordship can consider it. In the event that the defendants do not comply with paragraphs 2 to 5 of this order,
Let me write it down.
Of course, ma'am.
Yeah.
So in the event that the defendants do not comply with paragraphs 2 to 5 of this order, and then in brackets or any of those paragraphs, the defendant, close brackets, the defendant's statement of case shall be struck out. And then it goes on to say, the question of whether the defendants have complied. Sorry,
hold on.
I'm so sorry.
Defendant's statement of what?
The defendant's statement of case shall be struck out. So the defendant's the defendant's defense.
Yeah.
And then the question of whether the defendants have complied with this order will be determined at a hearing on the 22nd of March.
At 22nd, did I say? Yeah.
Yes, I believe you did, Mark.
22nd March 2022 at 9 o'clock UK time. Has the time difference changed by then?
I don't believe. We'll check. I don't believe it will have, but we'll check.
So that would be 1 o'clock UAE time.
Yes, yes, my lord.
And that's instead of the wording I suggest, which it seems to be. What I would suggest is the question in the wording you put in, the question of whether the defendants complied with this order, defendants have complied with this order, and the consequences of non-compliance.
Yes.
And the full consequences of non-compliance. If established. Shall be determined at a hearing. Now, does that undermine the first part of the sentence?
Well, it might do to a degree, but I think it's probably good enough from our perspective. I mean, you've specified one context, but you've also given the court a discretion later to order some other consequence.
Do you want to work fully in the event that the defendants do not comply fully with those paragraphs? What I have in mind is an affidavit which is appears to address and is rather ritualistic and just says, I've done this without any proper explanation.
Yes, I agree. I think fully would help, my lord.
And that would go after the, so what we'd do is renumber 2 would become 1.
Yes.
3 would become 2. It occurred that there was a problem, it seemed to me, with 4, in that the defendant doesn't have a legal representative.
I'm so sorry, my lord. It may be that you're looking at, we've updated the order, and it may be you're looking at the version.
That's an updated order at one point.
Whereas might have been sent to you this morning, but if not, it's on case lines as well, I believe.
I've got the one updated on the 1st of February.
No, there was one that should have been one uploaded this morning. Where is it? Oh yes, sorry, my lord. It's I mean, it's in bundle. Do you have the case line system?
Yeah, under M.
It's under M553.
Right.
Now we've sent this order over to the defendants this morning, but can I explain? Yeah. It doesn't actually materially change what we've done before. Can I just explain to you what the changes were? So in our evidence files on the 1st of February, we had set out the sort of the general scheme to this order, and then in our skeleton argument, we provided your lordship with a schedule of all of the slightly more granular complaints that we've made about the defendants, and that was obviously sent to the defendants when we filed our skeleton. And in this order, what we've done is broken that schedule out into 2 parts. So there is now the part that deals with the defects in the affidavits, which was a breach of the October order and which we seek an unless order for, and then other more generalised complaints where we don't seek an unless order. So what we've done is broken those out into Schedule A and Schedule B, and we would on the order that your lordship is looking for, we're only seeking the strikeout consequence for what you can see as paragraphs 2 to 5, and we've got rid of the legal representative provision for the reasons that your lordship has identified.
Right. So. Just give me a second to look at this. Right, so Schedule A and B are taken from the composite schedule attached to your skeleton argument, is that right?
That's right. And we've just Schedule A are the specific granular complaints about the affidavits, and Schedule B are more generalised complaints. And on those more generalised complaints, we're not seeking the strikeout consequence.
Right. Give me a second. So. Do 2, 3, 4, and 5 they cover Schedule A or Schedule B?
So 3 covers schedule. Can I just explain perhaps just in a bit more detail, the scheme of the order. So paragraph 2 deals with the internal investigation documents. They're a standalone category.
Same as previously.
Same as previously, yes, my lord.
Wording the same?
The wording is, I believe, the same. Can we just check? But I don't believe it's changed.
I imagine by the time the registry issues this, it'll be tomorrow. Sharla. Sharla, are you there?
Yes, Your Honor. Yes, Your Honor.
Is it likely this order can be issued tomorrow?
Yeah, I'll work on it. I can try to work on it and have it issued tomorrow. Yes.
So if tomorrow is the 2nd, so 7 days would be the 9th, I think. And 14 days would be the 16th. Right. Okay. Maybe your solicitors could update this as we go along. So the date in paragraph 2 would be the 9th of March.
That's right.
Date in paragraph 3 would be the 16th of March, 2022 in each case. Right, and we ought to emphasize that it's against the first, 4th, 5th, 6th, 7th, and 8th defendant. So how would that? I think somewhere right at the beginning, it ought to say. I think before it is hereby ordered. Sorry, I think what we've got to do is split out the bits that concern the first part of the hearing this morning and say, upon hearing, you obviously for the claimant and Mr. Al-Hashimi for the third defendant. And then it is hereby ordered that the immediate judgment, the third defendant's immediate judgment application is dismissed. 2, that the third defendant pay the costs of and occasioned by that immediate judgment application on an indemnity basis. To be assessed by the registrar if not agreed. And 3, that the claimant's unless order application, which I suspect is defined somewhere.
We can define it. We'll define it in the recital.
Claimant's application for an unless order insofar as directed at the third defendant is. What do we do with it? We agreed it wasn't to be pursued today, so is adjourned.
Adjourned with liberty to restore.
Adjourned with liberty to restore.
My lord, just going back to two. On 2, your lordship also kindly directed that assessment could take place immediately. So I think it should say you can add at the, so it should read, the third defendant shall pay the claimant's costs of and occasions by the immediate judgment application on the indemnity basis, and the cost shall be assessed within 14 days if not agreed. If your lordship's content with that.
I'm reluctant to put a time limit in which wasn't discussed.
Well, your lordship said
to be assessed by the registrar if not agreed, such assessment with liberty to apply for such assessment immediately.
Fine.
I imagine there's maybe some better wording if you can think of something.
We'll have a think, but I think that hits the target, my lord.
3 was the adjournment of the application against them, and then secondly, then you break a bit, and upon hearing this Alanud Alareki, purportedly on behalf of the 1st, 4th, 5th, 6th, 7th, and 8th defendants. And then whatever, imagine we carry on consecutive numbering 4, that the application made on behalf of, made orally on behalf of those defendants for a stay of proceedings, stay of these proceedings, is refused. I don't think one needs to spell out what the application is, unless you think otherwise.
No, I'm content.
And then further gap, and then upon hearing Mr. Shivji, QC, on behalf of the claimant, there being no representation on behalf of the 1st, 4th, 5th, 6th, 7th, and 8th defendants. It is hereby ordered. I think it's a bit clunky, but I think one has to separate out the bits that went before we get to this part of the order.
I'm grateful, my lord. I agree.
And then the numbering will probably start about number 5 then.
Yes. And so that will pick up the existing 2, which was the internal investigation documents.
So we're leaving out 1 for the moment. Is that right?
Yes, yes, my lord.
So
and that 2 hasn't changed from the
2 will become 5. Yeah.
Yeah. And that hasn't changed from the original. Sorry. Oh right, I'm so sorry, my lord. The words, but were they in the February order? Yeah, fine. So my lord, the words in brackets in what is 2 on the order in front of you were not in the application when issued, but they were within the form of the order served with our supplemental evidence.
The one I've got, yes. They're in the one I've got.
I'm grateful. So then we move on to 3, which is now 6. We'll insert the date there of the 16th of March.
Yep.
And what we've done there at 3B.
When you say affidavits, should it be affidavits or witness statements?
Yes, that's fine. Well, sorry, perhaps I could. It's very rare for me to insist on an affidavit, but I wonder whether it should be affidavits. That is what Mr. Justice Giles ordered at the last hearing.
Let's be consistent.
I think so, and I mean, one slightly worries about the defendant's compliance, but perhaps it will give them pause for thought if they swear an affidavit.
Right. Okay. Anyway, there's no harm in consistency occasionally.
I'm grateful. So then on 3B, what we've done is added some words to at the end of the order as set out in the Schedule A to this order.
Yeah, yeah.
And that schedule is the schedule attached to my skeleton, which is now bifurcated into A and B. But that's just for clarity. It's actually to help the defendant so they understand what the target is that they need to hit.
Yeah.
And then
6.
Moving on, so that was 6. And then moving on to 4, which is now 7.
Oh, the previous 4 has disappeared, the legal representative one. Yeah. So this is 7. The defendant shall provide the claimant copies of each of the documents mentioned in paragraph 53. Can you help remind me what paragraph 53 is about? You're mute.
So sorry, my lord. These are the documents mentioned in her affidavit. So the DIFC has a very similar regime to the English CPR 3112, where if a document's mentioned in a statement of case or a witness statement, a party has a right to inspect. And the documents themselves relate to other facilities with other banks that the defendants entered, or the litigation in relation to those facilities. And in her affidavit, she has a long list of facilities and onshore proceedings, and we would like copies of those documents.
Should it not be then the 7th defendant shall provide copies?
Well, it's not necessarily the 7th solely in the 7th defendant's control. As we understand it, these are documents within the defendant's possession, and we don't want to release the other defendants from the obligations simply because the 7th defendant says I don't have control over them.
Okay. Yeah. All right.
And
that's by the 16th again.
Yes, my lord. And then the next one is a shorter one, but it's the same rule 28.5. They have an attendance book for one of their offices, and we had a sense of it from Miss Alanud earlier on. There is a point that they're taking about the date that we say the facility was signed, and we have put in, we have alleged that it was on the 31st of May. There is some evidence to suggest that it might actually have been later on that week and that the date might be off by a day or so, but they won't let us look at the attendance book to see who attended the offices on other days. And we say we ought to be able to see that. And that is, again, a document that's mentioned in a witness statement. So we say we have a right to inspect.
Are you wanting just a copy there?
Yes, we've asked for a copy of it, which is fine.
You don't want the original document.
I think for the time bit that there's a slightly long story to this, but we did have a physical inspection a while ago, which was an unhappy affair which resulted in the defendants making allegations against my client's legal representatives, which have not been pursued. But that was an unhappy episode, and so we'd rather deal with them at a degree of distance.
Yeah, all right.
And then moving on to 6. So these were the general complaints in the schedule to my skeleton. They don't need to have the strikeout consequence, certainly not at this stage. I'm not asking for it.
Yeah. Then, sorry, and we make clear that the strikeout applies only to paragraphs 5 to 8, therefore. Is that right?
Yes, that's correct.
Yep. 9 then becomes, oh, sorry, so 9 is that one inserted. So 6 becomes 9.
6 becomes 9. Now 7 relates to
no time limit on 6.
Oh, your lordship's actually right. There ought to be. We'd say it again on the 16th of March.
Yeah.
Then 7 becomes 10. The date should be the 16th of March again.
The date on a date before 16th March.
Yeah.
Yeah.
And then the new, I suggest a new 11, which deals with this sanction wording that Your Lordship and I talked about a moment ago.
Yeah. So hang on a sec. So this will be 11, you say?
That's right.
Yeah. In the event the defendants or any of them? No, just the defendants.
I think, or any of them, I think is helpful.
Do not comply fully with paragraphs. It's still 5 to 8
Yes, that's correct.
of this order, or any of those paragraphs. The defendant's defence shall be struck out. Full stop. The question of whether the defendants have complied with this order and the full consequences of any non-compliance shall be determined at a hearing on 22nd March 2022 at 1 p.m. UAE time. Do we need a separate paragraph fixing that hearing? Determined at a hearing, at the hearing specified in paragraph 12.
Yes.
I just think it's useful to have a thing fixing a hearing.
Agree. Does Your Lordship want to include a time estimate for that hearing?
Does it achieve anything?
No, probably not. I mean, we're in Your Lordship's hands, it's fine.
I suppose a 3-hour estimate. It depends if anyone turns up.
Yes, and when they turn up.
But if there's an allegation of non-compliance, there may well be the need to go through bits to work out whether a strikeout is the appropriate course. And if you get some purported compliance by one defendant but not by others, whether you have to treat them individually and so on. So time estimate of 3 hours. It may be much shorter.
I think that's appropriate.
And then paragraph 13. Costs to be. I think again you only served your schedule of costs this morning, and I don't think it's right that I should assess costs. I think it's. I'm just wondering what order to make for costs, since part of the costs are already covered by a previous order.
Well, I think it would only be it's the cost of the unless order application. So Your Lordship has made costs on the immediate judgment, and we will apportion the costs of today so that they're fairly allocated.
how do I express it so that it is, we haven't yet defined either the immediate judgment application. I don't think it's even referred to, actually.
No, because this was our unless order application, not this. We didn't intend to deal with. But what we'll do is we'll put a recital in, my lord, that defines
the immediate judgment application and a recital about the unless order application.
Yes.
And then paragraph 13 will be the costs of an occasion by the unless order application to be assessed if not agreed. Assessed by the registrar if not agreed.
Yes, that's right. Would your two things, my lord? One is we would ask for that on the indemnity basis for the same reason as this morning.
I think that is a slightly different category for this morning's indemnity basis for the immediate judgment application. It seemed to me that should all, I mean, you can defer the cost of the immediate judgment application because if it's coloured by the light of the response, there may well be grounds for an immediate judgment, for an indemnity basis for the whole immediate judgment application. If there is a good response with good explanations in accordance with paragraph, whatever it is, paragraph 6 of the revised order, saying, in other words, challenging your assertion that there wasn't proper information or they could have provided more, then it may not be appropriate to make it indemnity costs. Do you want to simply to reserve the cost of the unless order application until the hearing in 2 weeks' time or 3 weeks' time?
Well, perhaps I could just have a go at trying to persuade your lordship on this point.
Right.
Our point is this is not about the substance of what they might say in due course. We've issued an application. We issued it back in December at a point when they had legal representatives. On the date where their evidence and answer was due, they had legal representatives and they filed no evidence and answer. And it was after that their legal representative then applied to take himself off the record. So they knew about the application, they knew what was alleged, and they didn't even respond to it to say that the application's misconceived because we've complied. And so it like any other application, if a party just chooses not to engage, then that is not appropriate behaviour on the application. And it's all the worse, we say, because this application concerns compliance with the previous cost order made by this court. So we would say that is unreasonable conduct that takes it out of the norm that would justify indemnity costs.
Yes, I'd forgotten the timing of that. So pay the costs of an occasion by the unless order application on an indemnity basis to be assessed by the registrar if not agreed, with the same provision about can apply immediately.
Yes, please, my lord.
Whatever the wording was.
Yeah, you liberty to apply be immediately for assessment, but I'll look at. I'm not sure I've taken a very good note of that. Well, my junior has, and we will look at that wording and we'll send it over to your lordship for approval.
Yes, well, you send it to the registry, and Charlotte can email me. If you can do that fairly soon,
Yeah.
then it can be emailed to me during the course of today.
Yes, Your Honor.
Thank you very much, Charlotte. Is there anything else that needs to go into the order?
Can I just check with my team? My lord, just take 20 seconds, if I may.
I should say, if it's easier as a matter of getting the order, the discrete parts done separately, to have 3 separate orders, by all means do so. I'd have thought it's not necessary, but is that the matter for you?
I think we agree. We'll do it in one order, and we should be able to get it to you very quickly. If I may, I'll just check with my team that there's nothing else.
Yeah. You're mute.
My lord, my learned junior makes a good point that we, just for clarity, we will make it clear on paragraph 13 that costs order only applies against the defendants that your lordship is ordered against, because for the third defendant, that application's been adjourned. So we'll make that clear in the drafting.
It must be made clear actually for the whole of the.
Yes, for the whole of those operative provisions for the unless order application.
Sorry.
For all of the operative provisions for the unless order application, we'll make clear that they only apply to the first, fourth to eighth defendants.
Yes. You could put at the end when it says in the previous bit where we say you've adjourned the application as against the third defendant, liberty to restore, say something like, in consequence, none of the orders made at paragraphs whatever to whatever apply to the third defendant.
I'm grateful. We'll include that.
Something that might make it clearer. Very well. Is there anything else that needs to be done? Charlotte,
No.
have you got any point you're concerned about?
No, Your Honor, it's all good to go, and I let my teammates know that we have to issue this by tomorrow, and we're ready for it.
Fine, thank you very much.
My lord, just one point by way of clarification. I think I mentioned it as I went, but just so that I'm clear, on paragraph 9, that was a new insertion because Schedule B didn't appear in our previous order. But as I said, we're not seeking an unless order for that, and Schedule B was part of my skeleton.
Yep. Yes. And you're not seeking an unless order as regards the computer either.
No, not at the moment.
Yeah. Okay.
I'm grateful, my lord. We'll get that over to you as quickly as we can today. And I know your lordship took on this hearing at short notice, and you've had to do a lot of pre-reading, squeezed into my slightly unrealistic time estimate. So I'm grateful for your lordship's time.
But if you can advise your colleagues and instructing agents and so on about time limits, time estimates, that would be useful.
Well, I appreciate that. I can't point the finger at them. I take that responsibility for that, my lord. So I'm sorry about that.
That's right. Anyway, thank you very much for your help, and probably see you in the hearing on the 22nd of March. 22nd?
22nd, yes, my lord.
That's yes, 22nd of March. Yep. Thank you very much.
I'm grateful.